Well, good afternoon and welcome everybody. Thank you for joining us for this short webinar on discrimination law. It's fair to say the common law got off to a rather slow start on this topic because it was only as recently as 1998 that Lord Hoffman said that equal treatment was an axiom of rational behaviour in Matadine and Pointu. But we do, however, have very significant statutory framework for dealing with equal treatment. Much of it is from Europe. Some we must now learn to call retained EU law while we can. And some, of course, from the Convention on Human Rights. What we're going to do this afternoon is talk about three hot topics. We have three excellent speakers, all of whom promise to speak for only about 10 minutes each. Firstly, Azim Sutawalla is going to talk about the surprisingly vexed question of the nature of justification under Article 14 ECHR. Then Keir McAndrew is going to talk about the potential for discrimination arising from algorithms. And then finally, Michael Armitage is going to address positive discrimination and a recent Supreme Court case that I think he still feels a little sore about. What we will do in the interest of time is keep the discussion to the end, if you don't mind. Feel free to post questions on the Q&A, and if time allows, we will try and address them at the end. The target is to finish at 1:45. With that, if I may, I'll hand over to Azim.
Thanks very much, Tim. I'm going to share my screen. Hopefully that will work. And we can see, yes, I'm going to start the slideshow. So hello everyone. As you can see from the title of my talk, I'm going to be talking about Article 14 of the European Convention on Human Rights and the test for justification under that article, and to look in particular at where we have got to on justification. So let's have a recap, if we can, first of all, on the test for breach under Article 14. You see the 4 points there. Does the alleged discrimination fall within the ambit of a convention right? Number one. Number two, is the alleged ground of discrimination a status falling within Article 14? Number three, has the claimant been treated less favourably than a class of persons whose situation is relevantly similar? And number four, and the all-important hot topic for today, is there an objective and reasonable justification for the difference in treatment? Now, again, stages for the test for justification. It is a four-stage test, and we're really focused on the fourth, but we'll run through them very quickly before turning to the fourth. Number one, does the measure have a legitimate aim sufficient to justify the limitation of a fundamental right? Number two, is a measure rationally connected to that aim? Three, could a less intrusive measure have been used? And finally, has a fair balance been struck between the rights of the individual and the interests of the community? And that's the real focus of the talk today. The issue there is what standard does the court use in assessing whether this test has been satisfied, the fair balancing test? What standard of review does it engage in? Now, this issue has recently come to a head in the second, what became known as the second benefit cap case, the DA case you can see there in the first bullet point. And that followed on from an earlier decision in the SG case in the Supreme Court, the first benefit cap case, in which the claimants had been unsuccessful. The second case was brought after the then government revised downwards the limit of the benefit cap, and that revision was again challenged by a series of claimants, and they claimed that they had been unlawfully discriminated against under Article 14, taken together with the right to property, i.e. welfare benefits, under Article 1, Protocol 1, and also the right to family life. And on the test for justification of less favourable treatment, Lord Wilson, who gave the lead speech, observed that the Supreme Court had been proceeding down two different paths in its search for the proper test for justification in respect of an economic measure introduced by the democratically empowered arm of the state. And this reference to duality was, on the one hand, a series of cases culminating in the DA case, where the test for justification employed was whether the treatment, the less favourable treatment, was manifestly without reasonable foundation, what's become known as the MWRF test. And that test had been used in a number of cases prior to DA, in cases involving matters of socio-economic policy. And I just give you two examples here. The first is the Humphreys and Revenue Customs case from 2012. And that was a case involving a challenge against discrimination against men receiving child tax credit. And the test employed by the court in rejecting that claim was that the less favourable treatment was not manifestly without reasonable foundation. Another controversial example is the bedroom tax case, the MA or Carmichael case from 2016. And that was a challenge against regulations which capped housing benefits, where it was deemed that an individual had more space or room than he or she needed for their social housing needs. And in that case, the disabled claimant succeeded in the Supreme Court in showing that they had been discriminated against, whereas a claimant claiming that she required extra housing to escape physical harm had her claim rejected by the Supreme Court. In respect of both claims, the court unanimously affirmed that the test on justification in these sorts of cases was whether the less favourable treatment was manifestly without reasonable foundation. On the other hand, we've had cases such as the Bank Mellat case and the Quila case, which you see from the fourth bullet point there on the slide. The Bank Mellat case is the case which concerned measures taken by the Treasury to restrict access to the UK's financial markets by a major Iranian commercial bank on account of its alleged connection with Iran's nuclear program. And in allowing the bank's claim, the Supreme Court adopted a standard approach to the objective justification test, namely a standard proportionality approach. In the Quila case, that concerned whether a ban on the entry for foreign spouses or civil partners, unless they were 21 or over, was a lawful way of deterring or preventing forced marriages. And again, the Supreme Court found that that measure by the Home Office was flawed and failed the standard proportionality test, and that the Secretary of State had failed to justify that the measure was no more than was necessary to accomplish the objective of deterring forced marriage. And as Lord Wilson memorably said, on any view, the measure was a sledgehammer, but the Secretary of State had not attempted to identify the size of the nut. So how has this duality come about, and is it here to stay? Well, we go back to the earlier decisions of the European Court of Human Rights, and I've cited two in particular. The decision in James in 1986, which concerned a challenge against leaseholder enfranchisement, and that being in breach of the claimant's Article 1, Protocol 1 property rights. And in that case, the European Court of Human Rights rejected the challenge, and in doing so, relied upon what it referred to as the manifest without reasonable foundation test. And in doing so, referred to the margin of appreciation and the fact that the national legislature was much better placed to understand issues of political, economic, and social matters where opinions differed. Similarly, in the Steck case, which is a 2006 decision, the European Court of Human Rights was concerned with the challenge relating to alleged sexual discrimination in the payment of reduced earning allowances by reference to pension ages and the differences that had on men and women. And again, the point was made by the European Court of Human Rights that because of the national legislature's direct knowledge of their society, they were better placed than the international judges to appreciate what is in the public interest on socio-economic grounds, and therefore they would not rule that a measure was discriminatory unless it was manifestly without reasonable foundation. That approach was the one that was carried through in discrimination cases generally up until and including the DA decision, and we've obviously looked at a couple of those. But in the meantime, in 2015, a case came before the Supreme Court in which Lord Mance gave the leading speech, and that's the recovery of medical costs for asbestos diseases case, which I've cited in the third bullet point on this slide. In that case, the judge, Lord Mance, questioned whether the manifestly without reasonable foundation approach was the correct one, and decided that because that approach had emerged from the European Court of Human Rights adopting a margin of appreciation, and that at the domestic level there was no need for a margin of appreciation, that the test was not required to be used by the domestic courts. The domestic courts did not have the same disadvantages of physical and cultural distance as the European Court of Human Rights. And whilst the domestic courts had to give appropriate weight to informed legislative choices at the fair balance stage, that fourth stage, nevertheless, it had a significant role to play in carrying out a balancing exercise. And as a consequence, when we get to DA in 2019, the court is divided on this, notwithstanding that the division is heavily weighted against Lord Kerr and Lady Hale, they're in the minority. They take the position that the test, the MWF test, was the product of the European Court of Human Rights margin of appreciation test, and therefore used in a different context. It had been wrongly imported by the domestic courts, and Lord Mance had been right in what he had said in the asbestos case. However, all the other judges in the Supreme Court disagreed with Lord Kerr and Lady Hale. And in respect of that, Lord Carnworth in particular was of the view that, notwithstanding he accepted that the MWRF test had emerged as a product of the margin of appreciation approached by the European Court of Human Rights, that did not mean that the domestic courts could not use that same test, and they had done so, in his view correctly, in considering discrimination cases bringing a socioeconomic bent. So you may say, well, given this split, and given that Lady Hale and Lord Kerr were in the minority, why does it matter? Well, as I've questioned, is it really the end of the matter? And in DA, Lord Wilson, as you can see from the quote, was very intent on ensuring it was the end of the matter. The problem is, since DA, that the bedroom tax case that I've referred to has gone to the European Court of Human Rights, and judgment was given after the decision in DA. And in the bedroom tax decision by Strasbourg, in its judgment, it chose not to refer at all to the manifestly without reasonable foundation test. And that's noteworthy, especially so given that it recited the fact that the claimants before the European Court of Human Rights had expressly said that was the wrong test used by the Supreme Court in the DA decision. And instead, in giving its judgment, the European Court of Human Rights simply said that the Secretary of State had failed to give weighty reasons justifying its position on discrimination in the lower courts, and on that basis decided against the Secretary of State. Interestingly, the European Court decided that the disabled claimants had not been discriminated against, but the sanctuary claimant had been discriminated against, effectively reversing the decision in the Supreme Court. The UK sought to appeal the decision to the Grand Chamber, but in March 2020, the Grand Chamber rejected that appeal or refused permission to appeal. And so we are now left in a position where the matter could, in fact, come back before the Supreme Court, and it will come back before the Supreme Court because we are waiting for a decision in the SC and CB case, which is pending in the Supreme Court, and that decision will again involve a reconsideration of the manifestly without reasonable foundation test. A final note on where we are: DA itself has gone to Strasbourg, and in the DA case, as I understand it, the European Court has expressly asked for submissions on the applicability of the manifestly without reasonable foundation test. So it really is, notwithstanding Lord Wilson's comment, as we see in the first bullet point, potentially all up for grabs, depending on which side of the fence you sit on. So there we are. Thank you very much.
Thank you, Azim. That's extremely interesting. And we're used to the idea of there being dialogue between our Supreme Court and the Strasbourg Court. But that has usually been the case of the Supreme Court politely explaining to the Strasbourg Court why it doesn't think the Strasbourg Court's own analysis is right. And on a number of well-known occasions, the Strasbourg Court essentially accepting that. But here we have our Supreme Court adopting what looked like a doctrine of the Strasbourg Court, albeit one that was potentially non-applicable. And then the question whether the Strasbourg Court is going to set it right. So very interesting indeed. Thank you. Now, just as interesting, even less certain, Akia is going to talk about algorithms.
Thank you, Tim. I'm just going to try and share my screen if you'll all bear with me. Now, hopefully that's worked. Thanks very much, everyone, for joining today. I'm going to spend my 12 minutes, as Tim has said, talking about discrimination in algorithmic decision-making. Apologies in advance if that doesn't sound like a particularly interesting title. It's a bit techy, but in my view, it conceals what truly is an extremely interesting issue in discrimination law. And it's one that's only likely to grow more important as public bodies increasingly use these kind of algorithms to make decisions. But what do we mean by it? Well, as with most things, I think the easiest way to explain is through examples. So I'm going to start off my talk by giving you a couple of examples of cases in which these kind of issues has arisen. And because all barristers love to talk about their own cases, you won't be surprised to know that these are a couple of mine. And then if time permits, I'll leave you with a few key considerations to think about if you're either acting for a claimant who wants to challenge one of these algorithms, or if you're on the public authority side, you're in the process of developing an algorithm yourself. So I'll start with my first case example, and it's the case of JCWI, Joint Council for the Welfare of Immigrants, and the Home Office. Now, JCWI sought to challenge the use by the Home Office of a computer tool, which was known as the streaming tool, which was essentially used to categorize visa applicants by nationality for the purposes of determining whether they would get a visa or not. And for applicants with what were thought to be suspect nationalities, they'd get a red rating. Good quote unquote nationalities would get a green rating, and those in between would get amber ratings. And if you had received a red rating, your application was subject to more intense scrutiny. You were probably required to wait a bit longer. And your application, was more likely to be refused. So to give a concrete example of that, the award of a red application would require to be justified to a more senior officer, whereas if the Home Office worker decided to refuse a green application, that would also need to be justified. So there's a clear difference in treatment. And JCWI claimed that this was unlawful on the basis of direct race discrimination, essentially on the grounds that were considered in the quite well-known Roma rights case, the reference for which is on the screen. In that case, Roma travellers from Prague airport were subject to more intense questioning by UK border officials. They were often asked to prove things that might have been taken on trust for other applicants, and they were much more likely to be refused entry to the UK. And the House of Lords said, well, that's clearly and inherently discriminatory on the basis of race, which includes traveller ethnicity and nationality, and said you can't do that. And in JCWI, we argued that reasoning pretty much directly applied. After the proceedings were issued, the Home Secretary agreed to review the streaming tool, and in particular the use of nationality. So we're still waiting to see where that comes out. But to my knowledge, that was the first successful legal challenge to a discriminatory algorithm being used by a public law body. So that was an example of algorithms being used in a way that is directly discriminatory. I want to briefly touch on an algorithm which potentially gave rise to indirect discrimination, and that was the off-qual exam algorithm. Now, no doubt you remember from last year that the algorithm essentially operated in circumstances where no students could actually sit their exams because of COVID-19 to generate an exam for each student. And it did this by incorporating within the mix the historical performance of that student, of the historical performance of the school which that student attended. And effectively, what that did was to bring down the grades of very high achieving students who unfortunately happened to be attending a school where there was no history of equally high performance. And there was an exception for smaller cohorts. So if you were in a class of 5 or less, you weren't subject to the standardization algorithm, and you could get what was known as a teacher assessed grade, so your teacher's prediction of how you would do. And so therefore there was some suggestion that that would be indirectly discriminatory against students who went to state schools, where there was, more likely to have larger class sizes, etc. Now, as many of you will no doubt be aware, socioeconomic status is not currently a protected characteristic under the Equality Act, and the Section 1 duty relating to socioeconomic inequality has never been brought in. So we were required to think of creative ways in which you could challenge this. And there was some evidence that suggested that Black and minority ethnic students were more likely to be attending state schools. And so there was an indirect discrimination argument there. Obviously, if the case had proceeded to a hearing, some evidence of that would have had to been put forward. As with any indirect discrimination claim, you're going to need to show a disproportionate impact on a particular cohort. But in any event, that didn't happen because, as I'm sure you know, the algorithm was withdrawn after quite a large public outcry, and the various claims never got off the ground. Just one point on the appeals process in respect of this algorithm. So the appeals process mutated over the very short time during which the algorithm was live. But at one point, you could appeal your standardized grades by reference to what you got in your mock exam. And this again was potentially indirectly discriminatory, for example, against students with disabilities who, for whatever reason, hadn't been provided with reasonable adjustments for their mock exams, or who, because of their disability, had decided to focus all their efforts on the anticipated, the real thing rather than the dry run. So when you're considering algorithms and whether there's any discrimination, you not only need to consider the algorithm itself, but whether there's any kind of external human element that may have been put in place potentially to mitigate the discriminating effects of the algorithm, but which may itself compound or the discrimination or introduce a different type of discrimination. So with those two hopefully illuminating examples, I want to just briefly move on to a few things to think about in cases in which you're either challenging an algorithm or you've been involved in the development process of an algorithm. And the first one is disclosure. Now, mention of the word disclosure usually makes most lawyers, including myself, shudder. But in the context of algorithm challenges, it's really important because the devil really is in the detail. And if you don't know exactly what the algorithm is doing, it's very hard to properly assess whether it's having any discriminatory effects. And much can be concealed behind some unintelligible words of code. So in any case where you're thinking of challenging an algorithm, one of the first things you want to do, whether that's either in the pre-action stage or at the point of issuing your grounds, is to request disclosure of a fully executable version of the algorithm. Now, the possibility for such disclosure has been recognized in other contexts. So for example, the ESI case that I referred to on the screen, that was a case in which a consultation had been run by NICE in relation to the criteria that they'd apply in respect of certain drugs. And as part of the consultation, they disclosed a read-only model a read-only version of the model which they use to assess the cost effectiveness of certain drugs. And the Court of Appeal said that's unfair. The respondents to the consultation need a fully executable model so that they can understand it and make intelligent representations about it. And so that reasoning has some application in the context of algorithms. Lord Sales, in a recent speech, has given a boost to the cause of disclosure. If anyone's interested in this area, I strongly recommend reading this speech in full, because it gives much more full and erudite treatment to these issues than I'm able to give. And it's really worth reading. But he says, look, if you're going to challenge the algorithm, you will need to secure disclosure of the coding in issue. And whilst that's obviously not binding authority, any High Court judge is going to be interested in what a serving member of the Supreme Court thinks about these issues. And just to note that if you're on the public authority side and you're involved in developing one of these algorithms, you should be prepared for a request for disclosure. And it's really not unforeseeable that you would have to disclose that in the course of proceedings. The second point that I want to talk about is the procedure for coming up with an algorithm. So the case examples that I focused on earlier, they concerned challenges to substantive discriminatory effects of an algorithm, but the procedure is also relevant. No doubt you'll all be aware of Section 149 of the Equality Act. It's an extremely long provision, and I haven't put it all on the screen, but essentially it requires public authorities to have due regard to the need to do a number of things, one of which is to eliminate discrimination, another of which is to foster good relations between people who share a protected characteristic and people who don't, and also to advance equality of opportunity in respect of those two cohorts. And in order to demonstrate compliance with Section 149, an equality impact assessment is usually, although not always, required. And again, in Lord Sales's lecture, he very clearly is of the view that if you're doing anything fancy with algorithms or data, you should be conducting an assessment of the impacts that it could have. But in addition, if you're developing an algorithm or if you're seeking to challenge one, you should also be aware that if your algorithm involves the processing of personal data, i.e. data that is capable of identifying an individual, you may also be under an obligation to do a data protection impact assessment. Now, the requirement for that is set out in Articles 35 and 36 of the GDPR, what is now the UK GDPR. And the key obligation is on Article 35(1), and I've set it out in summary at the bottom there. Essentially, a data protection impact assessment is required where processing, and in particular processing that uses new technologies, is likely to result in a high risk to the rights and freedoms of natural persons. And in my view, discrimination is a quintessential example of when there might be such a risk. And that's particularly the case when the algorithm is being used as assessing whether an individual can access a benefit, like, for example, a visa. And then, the article goes through as well what the assessment is required to consider. So, for example, whether the discrimination involved is necessary and proportionate, and what safeguards you can put in place. And there may, depending on the circumstances, be a requirement to consult with the Information Commissioner. So that's something else to bear in mind. Finally, in the minute that I think I've got left, expert input. Now, whether this is required will depend very much on the facts of the case. But if you are a public authority which is developing an algorithm, you will almost certainly require expert input in order to create it. And it is also worth considering whether expert input will be useful in determining the potentially discriminatory effects of the algorithm, i.e., are there any unforeseen consequences? Is there anything you can do with the algorithm that might mitigate those consequences? And if you're thinking of challenging an algorithm, expert input is also extremely useful. If you're anything like me, you will need an expert to help you understand how it all fits together. Now, that doesn't necessarily need to be expensive. There are lots of NGOs and freelancers who are interested in this kind of thing, and nor does it necessarily have to form part of the evidence which you put before the court, but it can be very useful in the background to enable you to properly understand the algorithm and map its practical effects onto the legal framework of discrimination. So with those very brief thoughts, I will leave you, but I'm very happy to answer any questions at the end of the session. Thanks, Tim.
Yeah, thank you very much. It's very heartening to see Lord Sales writing extrajudicially about the possibility of disclosure of algorithms, but prepare for an almighty battle if you're going to try and get one out of a tech company. Now, speaking of almighty battles, Michael is going to tell us about his almighty battle on the subject of positive discrimination. Mike.
Hello, everyone. Thanks to those who've spoken before. I'm going to see if I can make it 3 out of 3 in terms of successfully sharing my screen. How does that look? Okay, I'm going to assume that's fine. So I'm going to talk about the distinction in English law, if there is one, between positive action and positive discrimination, and the treatment of that issue by the Supreme Court in its judgment from October last year in the Zed and Hackney case. I should say immediately, this is another example of a barrister talking about one of his own cases. And so that I don't get all of the blame, I should say that Keir was also involved as junior counsel for the unsuccessful appellant in that case. And I should also say right at the outset, only very, very slightly begrudgingly, that the leading judgment of Lord Sales in that case is a real tour de force in a complex legal area that had not previously been considered by the higher courts. So for anyone dealing with positive action issues in practice, it really is essential reading. Sorry, before looking at the judgment, I thought it was interesting just to note some words from Baroness Hale, speaking to The Guardian, I think in 2019, on the subject of judicial diversity. Of course, she routinely called for greater representation of women and ethnic minorities in the senior judiciary. But it's notable that when she was asked about this in 2019, she expressly disavowed any suggestion of positive discrimination. So actually reserving spots on the judiciary for women, for example, and emphasised this point that nobody wants to feel that they've got the job on anything other than their own merits. And many of you may recall Lord Sumption suggesting in a lecture a few years ago now that without any kind of positive discrimination in the judiciary, it might take 50 years to achieve a fully diverse judiciary. And I think Baroness Hale is on record as saying she thought that even that was rather optimistic. So Baroness Hale is obviously there talking about the desirability of positive discrimination, but there's obviously a separate question as to its lawfulness. And I think it can probably fairly be said that, at least prior to the decision in Zed, positive discrimination was not generally considered to be compatible with the English law of discrimination. And when I refer to positive discrimination, I mean measures that confer a particular outcome or benefit directly on a member of a disadvantaged group. So a quota for a particular job is perhaps the classic example. And obviously the general position, as many of you know, is that under the Equality Act, direct discrimination on grounds of a protected characteristic is prohibited, generally prohibited, regardless of whether the discrimination favours or disfavours a disadvantaged group. So, for instance, it's just as unlawful to directly discriminate against a man in relation to, say, access to employment, as it is to directly discriminate against a woman. And that's because the relevant protected characteristic, to state the obvious, is sex, not being female. And the same goes for a number, although not all, of the other protected characteristics. There are some caveats and exceptions, which I won't go into here. So there are also, however, some exceptions to that general principle under the Act, general exceptions that are not confined to particular protected characteristics. And the one I want to talk about today in relation to the Z case is the one in section 158 of the Act, the so-called positive action provision. I've got the text there. It's a rather dense slide, but just to break it down, there are effectively two broad elements for this section to apply. So subsection 1, the alleged discriminator, if it's in the context of a claim for discrimination, has to reasonably think that, and then one of the 3 things from A to C have to apply. So the first one, for example, you have to reasonably think that the persons who share a protected characteristic suffer a disadvantage connected to the characteristic. And then there are some other similar provisions. And now on its face, that's a relatively low threshold because it focuses on the state of mind of the person with the relevant practice, albeit with a requirement of reasonableness, which incorporates a sort of objective element. But then one also has to show, as well as the the satisfaction of the reasonably thinks threshold requirement, that the action in question, this is subsection 2, is a proportionate means of achieving the aim of, and then there are various, again, provisions. So subsection 2A, enabling or encouraging persons who share the protected characteristic to overcome or minimize the disadvantage. And the three, you'll notice that the 3 subsections in 2 map directly onto the subsections in section 1. And obviously you have there the familiar formula, which generally applies in relation to indirect discrimination under the Equality Act, of proportionate means of achieving a particular aim. So the way this works, as you can see, is that it essentially provides a defence to a claim of unlawful discrimination. The Act does not prohibit the taking of any action which satisfies these requirements, notwithstanding that it would otherwise be prohibited under the Act. Another point to note is that this is a permissive, not mandatory provision. I'll be corrected if I'm wrong, but as far as I know, it's never a requirement under the Equality Act to engage in positive action. The position is that you can do so if the relevant requirements are satisfied. And I just pause there to note a contrast with the European Convention, where in certain circumstances, at least, Article 14 can oblige the taking of what might be called positive action. And there's the well-known Flimenos case, Flimenos in Greece, which is about the Jehovah's Witness who was refused appointment to a particular role because he had disobeyed in order to wear military uniform. But under the Equality Act, at least, it's permissive rather than mandatory, as I say. There are some other similar but narrower exceptions in the Act. One I should mention in particular is section 193 of the Act, which relates to charities. As we'll see, that provision was also an issue in the Z case, but I don't think I have time to get into the detail of it today. It's obviously of narrower application than section 158 itself. So I'll take this very quickly, but prior to the decision in Z, section 158 had received very scant judicial consideration. I've just flagged up there the one, I think one of the only cases in which it's even been mentioned, which was the Jewish burial case from 2019. And you see there that the divisional court made the point that in general, positive discrimination is unlawful under the Equality Act, in contradistinction to positive action permitted by section 158. So the divisional court there recognised a clear distinction between positive discrimination, which it said was generally not permitted, and positive action, which obviously is permitted under section 158. But given the facts of that case, it didn't need to grapple with the precise boundaries between the two concepts. So that brings us on to the decision in Z, where this distinction was squarely an issue. And just very briefly, the facts of Z, and these are set out clearly in the judgment, it was a case about discrimination in the allocation of social housing by a housing association called AIHA, Agudas Israel Housing Association. We can see from the slide some properties owned by AIHA in Stamford Hill, which, as many will know, is a heavily but by no means exclusively Orthodox Jewish neighbourhood in North London, in Hackney. And if one were to squint, you would see there the evidence of the policy that prompted the challenge in Z. And I've blown up the key text. You have an extract from an advertisement of one of the properties, and the text I've blown up, you can see that it specifically says consideration only to the Orthodox Jewish community. And the essential issue before the Supreme Court was whether it was lawful for AIHA to operate a policy whereby it would only allocate its properties to members of that community. And the appellant in that case was not a member of that community, but it was common ground that she was effectively the most needy applicant for social housing in the entire borough of Hackney, which is obviously no mean feat. And it was also common ground that as a result of the housing association's policy, members of the Orthodox Jewish community who were less needy in objective terms for social housing were allocated properties that could in principle have been allocated to the appellant. And importantly, when I talk about allocation here, I'm talking about allocation under the local housing authority's allocation scheme via nomination to properties held by AIHA. So it's perhaps unsurprising that it was common ground that this policy involved direct discrimination on grounds of religious belief. I say it's unsurprising because the policy deliberately discriminated against anyone who did not practice the Orthodox Jewish faith. There was also a disputed issue as to whether it involved direct race discrimination. I won't get into that in the time available, but it's dealt with in some detail in the judgment. Ultimately, that point was decided against the appellant in somewhat unsatisfactory procedural circumstances, but I won't say any more about that. If anyone wants to know about it, I can pick it up perhaps by email afterwards. But as I say, that's set out in the judgment. Now, in defence of the policy, AIHA relied on Section 158, as well as I've mentioned, the narrower charities exemption under Section 193. And the debate in the Supreme Court was all about proportionality. So it was accepted for the purposes of the appeal that the Housing Association reasonably thought that the Orthodox Jewish community suffered disadvantages connected to their protected characteristics. So as I say, the issue was all about proportionality. So conscious of the time, I just want to pick out briefly two important aspects of the judgment in relation to the proportionality issue. So the first point to emphasize, and I've put up here an extract from a European case called Briesch. The appellant in Z was relying on a, in my view, very clear line of authority on positive action in relation to access to employment in EU law. And we can see here a particularly clear statement of the approach of the Court of Justice of the European Union to such matters. The case was about a French rule whereby widows were exempt from an age limit for entrance to the civil service, but widowers were not. And very briefly, we can see from the emboldened text that essentially positive action measures are not permitted, or rather are only permitted if they do not automatically and unconditionally give priority, in this case, to women, in cases when women and men are equally qualified, and provided that the candidates are the subject of an objective assessment taking account of the specific personal situations of all candidates. And very briefly, the appellant sought to argue that by analogy, AIHA's policy was disproportionate because it essentially automatically and unconditionally favoured members of the Orthodox Jewish community and didn't allow for any objective assessment of other applicants' personal situations. And the very short point is, despite this, one might think, clear analogy with EU law, the Supreme Court gave these arguments short shrift and took a much more expansive approach. They said there was no analogy with EU law because the relevant EU legislation, and again, I'm paraphrasing, is concerned with securing equality of opportunity, whereas Section 158, as we've seen, is concerned with achieving particular outcomes. Now, with the greatest respect to the Supreme Court, I just want to note one query with that analysis. The query is that the EU legislation in this sphere has actually moved away from referring to equal opportunity and now talks about securing full equality in practice. So is actually rather similar in that respect to Section 158. And yet in the Briesch case, which concerned, in part concerned the new formulation, this very strict approach was taken. But the Supreme Court nevertheless was not convinced by that and took a much more expansive approach and took what might be thought to be a clear-cut case of positive discrimination, unconditionally favouring those who held a protected characteristic, was nevertheless permitted. And that's obviously got potentially wide ramifications going beyond the charities and social housing context. So looking at the time, perhaps I don't have time to deal with the second point in detail. I was just going to say, and you'll have the slides afterwards, there's also some interesting remarks in the judgment about proportionality on appeal. The Supreme Court in this case took the conventional approach that one can only, an appellate court can only interfere with a proportionality assessment at first instance when in short, when the first instance court's conclusion is demonstrably flawed or wrong in law. But it is interesting, and this is just to refer for those who are interested to another extrajudicial speech by Lord Sales, where he discusses, among other things, the Z case. I've given the reference there, and what he says that although in Z he considered that to be the appropriate approach, in fact there are cases in which it may be appropriate for appellate courts to take a more robust approach and essentially carry out the proportionality assessment for itself. Some examples that he gives are the benefit cap cases, the Nicklinson case on assisted suicide, essentially big and important social issues. And finally, just to note, he says that he expects lawyers to be prepared to argue in appeals which approach to proportionality should be applied. And that obviously is relevant to both discrimination cases and proportionality cases more generally. I've probably slightly exceeded my 12 minutes, but as I say, there's plenty to get one's teeth into in the judgment.
Michael, thank you. You have very slightly, but forgivably, as that was extremely interesting. Thank you very much. In terms of overall time, we're now just over 1:45, and of course, we'd be sorry to leave anyone who needs to leave immediately. But just to give a moment in case anyone has any questions, I might, if I may, ask Azim something which is a little collateral to the points you were making, which just relates to the independent review of the Human Rights Act. One of the things you're really talking about was the role of margin of appreciation in determinations by domestic courts. And I wondered if you had any views about whether that was something of general importance that could potentially be an area of focus for that independent review, or whether you think the Act works well in this regard.
That's a very interesting question, Tim. I mean, my sense is that it has, well, it's worked over the years, but as the DA case shows, I don't think it's been satisfactorily resolved. And I think the tension remains. And the obvious point is, and it's a point made by Lord Kerr in his dissenting speech in DA, is how can it be that with the most significant cases, one might say, that come before the Supreme Court, the margin of appreciation, or call it what you want, the manifestly without reasonable foundation test, is the favoured test, which is taken by the court, whereas in cases which do not involve such significant issues, a more in-depth approach is taken by the court by adopting the very weighty reasons traditional balancing exercise, as we saw, for example, in the Bank Mellat case. I think, to answer your question, I think it has worked fine since the introduction of the Human Rights Act, but the tension remains, and I don't think the matter has been resolved, and we will see that probably played out in the coming years.
Thank you very much, Azim. It's a really interesting topic of much broader implication. I see in the Q&A some comments for Keir. Is there anything you wanted to say about that now, Keir? Very interesting observations on the use of algorithms.
Yes, absolutely. Thanks, Tim. And thank you to the individual who's put forward the question. Just noting that Ofqual did in fact do some equalities analysis at the time. Of course, that's right. And the matter never got to court for an assessment of whether those assessments were compatible with Ofqual's obligations. I mean, obviously, the various clients that were seeking to bring judicial reviews would have wanted to be in a position to suggest that they were deficient in some way, but I completely accept that some work was done. And then secondly, there's a point been put forward that the mock exam aspect of the appeal was never actually finalised. Forgive me if I've got that wrong. I had understood that it was put forward by the Secretary of State as a potential appeal route, but apparently it was never brought into practice. So I'm happy to accept that correction.
Thank you. Well, thank you all to our three panelists for really excellent contributions today. And thank you to everyone for joining us in the middle of what I'm sure has been a busy day. I hope we'll see you again at another one of these Moncton seminars soon. I think I'm right in thinking there's another one next week. So enjoy the rest of your day, and many thanks indeed.